Liebe Teilnehmerinnen, ganz herzlich willkommen an diesem zweiten Tag des internationalen digitalen Festivals Latitude, Machtverhältnisse umdenken für eine dekolonialisierte und antirassistische Welt. Auch heute werde ich einen Großteil des Festivals auf Englisch moderieren. Aber dank unserer wunderbaren Simultanübersetzerinnen Lilian Astrid Gese und Tanja Barbian können Sie bei Bedarf auf der Festival-Webseite zum Kanal mit der Übersetzung switchen. Hello, everybody. A very warm welcome to you, the participants from all over the globe. We are tremendously honored by your interest at this second day of the digital festival Latitude, and we really hope that we will meet your expectations. My name is Prasanna Uman, and I'm the moderator who will guide you through these 3 festival days. Our aim is to develop findings together with you about how we can support decolonized and non-racial structures in our global society effectively, and also about how to establish an appreciating and solution-oriented culture of listening. So, when we look at the current raging discussions in numerous cultural institutions in Germany and the whole Western world, it literally jumps out at us. The time is more than overdue to ensure that uncomfortable truths regarding structural racism and colonial continuities are made visible at those places where they are constantly denied. Today, we will focus on the topic dealing with cultural property and restitution. Throughout, this festival offers a mixture of practice and theory, serious and humorous views, and what is most important, many different perspectives. Let's catch a short glimpse in the program of the first half of the day. Before I joined, Joseph Kamaru and Sven Kaczirek already conducted a listening session, which will take place again tomorrow morning. To participate, you can register in advance on the festival website. And then, we prepared literally food for your soul, a talk with food blogger Osos Soko. Tell me, have you ever tried bean fritters yet? Let's see. And we will also present a second episode of Colonial Gymnastics, short Colonistics, by the wonderful Joanna Tischkau. Plus, we will also show another piece of heartbeats and poetry with MC and poet Eric Wanke. You can find further information and available translations on the festival website. Not to forget, we are also broadcasting a radio program. Latitude on Air is streaming on Reboot FM. And now we will start with proper brain food. In the panel, Learning from Each Other, Restitution as an Ethical and Legal Challenge with 5 participants from 5 different countries. Cultural and social anthropologist Larissa Förster, who is the head of the Department of Cultural Goods from Colonial Context at the German Lost Art Foundation, will moderate this huge and complex panel, including a live Q&A session. It would be wonderful if you could share your questions, comments, or even applause on the social media channels which are connected with Latitude. That is Twitter, YouTube, and Facebook. So I drop out now, and we will meet again at 15:30 Central European Time. Enjoy and stay tuned. And Larissa Förster, the digital floor is yours. I'm handing over.
Thank you very much, Prasanna, and hello and welcome to everyone who has decided to join us today. I'd like to welcome you to our panel called Learning from Each Other, Restitution as an Ethical and a Legal Challenge. And before I quickly introduce the panel and our speakers, let me briefly say who I am. I'm Larissa Förster. I'm a social and cultural anthropologist, and my research areas are the memory of colonialism, the coloniality of museums and their collections, and in particular, the debate on colonial provenances and the return of cultural heritage. And one of my focuses in this regard is the cultural and political relations between Germany and Namibia. And since last year, as Prasama mentioned, I'm the head of the department Cultural Goods and Collections from Colonial Contexts at the German Lost Art Foundation. And let me just briefly explain what kind of institution this foundation is, because many of the people who've joined us globally will probably not know. This institution was established in Germany 5 years ago in the aftermath of the so-called Munich art find. That was an art find of supposedly Nazi confiscated art. And the institution was established to foster provenance research on cultural heritage, Jewish cultural heritage that was expropriated during the National Socialist era. And we've now joined this institution with the topic of post-colonial provenance research and return. I'm very happy that we can take up these really difficult issues here, issues that have already been addressed in the opening panel. Johannes Ebert pointed out in that panel, or in his welcoming words, the momentum of the debate on post-colonial restitution. I'd like to add that I really believe that, at least in Germany, where I'm based, we've witnessed a kind of watershed triennium with the years of 2017 to 2019, because a new momentum has emerged in the debate on the colonial legacies of museums. For example, in 2017, the museum world started engaging with the pertinent questions, and the criticism of the Humboldt Forum really peaked, and it stirred a very broad debate on the issue of provenance and restitution. Then we've had the announcement of Macron and the report by Sarr and Savoy, and I think this report was really a very historical moment. And eventually we can even see politics implementing tools that aim to address the issue on an executive level, after all. That's what I think happened in the last year. However, and that's also something that has to be taken into account, we have not seen very many returns happening. In Germany, we've had a number of returns of human remains, but we've had only some 3 returns of cultural artifacts. And I believe this is where ethical and legal questions come in, structural questions also. Let me mention one of those questions that are repeatedly asked in this context. For example, do we need, for the return of objects acquired unethically in the colonial era, do we need a soft law framework like the Washington Principles that have been declared for Nazi confiscated art? There's different answers to this question, and I assume that our panelists would give different answers. But what is important is that the question opens up a comparative horizon, and it sets the stage for an approach of learning from each other. How can we in the field of post-colonial debate learn from the field of post-Nazism and the post-Holocaust debate, but maybe also vice versa? How can we benefit from insights gained in these different fields? So the aim of the panel is to relate the different struggles for historical justice and for the return of cultural heritage across the globe and across history. So we'll be looking at Jewish cultural heritage and the struggle for its restitution, but also African cultural heritage, or more broadly, cultural heritage of formerly colonized regions of the world. As it has been phrased in the abstract of this panel, the debate on restitution tends to get stuck in controversies. And there is some good reasons why it does. But nevertheless, in this panel, we want to go beyond controversy and suggest that there's a lot to learn from each other in terms of the challenges, the possible approaches we can take, the methodologies for working through difficult legacies and difficult heritage. I'd like to reference Michael Rothberg here, who's emphasized how making such connections between the different historical debates can create spaces for solidarity and for joint struggle. So I think it's a very explorative panel. I'm looking very much forward. We'll have 4 panelists, and the structure will be as follows. First, we have half an hour with the 2 of the panelists, then another half an hour with 2 panelists, and then a concluding session with all the panelists, where you can also from the chat or through the chat throw in questions. Yeah, so let me turn over to the first encounter between Leora Bilsky and John Nakuta. So hello and welcome to our session, Leora and John. I'm happy that we can meet here online. And with this panel, as I said, we want to set the stage for a comparative or maybe rather relational view analysis of processes and debates. Can we learn from the evolution of the debate on Nazi-looted art and from the institutionalization of NS provenance research and its restitution mechanisms? Can they serve as a model? That is some of the questions that I'd like to throw up. And I think the particular focus of this panel is also what Leora in our conversations before the panel called community-centered approaches to return. And I think that's really interesting because there's examples for that in the debate on post-Holocaust restitution. And I think the post-colonial debate is also very much on community-centered restitution. I'll briefly introduce the 2 panelists. Leora is the Benno Gitter Chair in Human Rights and Holocaust Research at the Tel Aviv University Faculty of Law, and she's also the director of the Minerva Center for Human Rights. She's authored books like Transformative Justice, Israeli Identity on Trial, and The Holocaust, Corporations and the Law, Unfinished Business. Her main areas of research are law in the Holocaust, political trials, transnational justice, international criminal law, but also feminist legal theory and the relationship between law, history, and memory. And her current research focuses on restitution and cultural genocide, among others also on the work of Raphael Lemkin, who's been so instrumental as someone who's been driving the debate on the Genocide Convention. So I hand over to Leora, and I'd just like to let Leora start to elaborate her argument about an early wave of restitution claims for Jewish cultural heritage and how that can provide us with insights for the debate that we are currently having about colonialism at museums. So the floor is yours, Leora.
Thank you, Larissa. Hello, John. I'm very thankful for inviting me, and I see it actually as a real opportunity to learn, because my focus till now was mainly on Holocaust restitution, and I'm looking forward to the discussion on post-colonial restitution. So I want to suggest to look at 2 waves of cultural restitution, Jewish cultural restitution. And I want to suggest that going back to the earlier wave of the 1940s and 1950s allow us a better comparison to the kind of claims and methodologies and approaches that are now put forward by the Savoy report and other efforts in the post-colonial arena. So, notwithstanding the temptation to compare the current post-colonial campaign to the 1990s campaign to restitute Nazi looted artworks, I think that the more fruitful comparison is with the earlier 1940s and 50s Jewish restitution campaign that revolved around the restitution of books, archives, and religious artifacts. So let me just briefly say why I think there is a mismatch between the 1990s artwork restitution and the colonial, post-colonial restitution. So the Holocaust 1990s restitution campaign adheres to a private property paradigm. It focuses on rare works of art with huge economic value. It is brought forward by private individuals and involves complicated provenance research and a case-by-case incremental restitutions. In contrast, the campaign for post-colonial restitution, as epitomized by the Osori report, is based on a collectivist paradigm. It is brought by African states, demanding the return of their cultural heritage from European museums. It envisions a massive return of African collections and articulates its demand in holistic terms, the return of culture, thus resisting the narrower focus on rare works of art, as in the 1990s restitution. Most importantly, although the post-colonial struggle is over objects, its real aim is the rehabilitation and reconstruction of the colonized community by reconnecting it to its lost cultural heritage. In other words, it sees restitution through the prism of memory as the return of memory and understand it as part of a healing process and of dealing with a traumatic colonial past. This leads me to return to an earlier wave of restitution that has been mostly forgotten in international law, which is the 1940s and 1950s restitution, which was based on three big assumptions that are different from the 1990s. I would say it is based on collective restitution as opposed to individual restitution. It was a restitution to the Jewish people as such. It was rejecting a backward-looking restitution, a legal restitution based on legal ownership, and advocated for a forward-looking restitution to the new centers of Jewish culture, like in the United States or in Palestine. And it looked at restitution in terms of reconstructing the whole culture. So these are three axes that are very much similar to what we see in the Osori report. But most important, this restitution is trying to begin the conversation with the novelty of the crime, a crime that that is not only about mass murder or physical injury, but it is about culture, the attack on culture. And it involves not only, it involves the academia, research institutions, and it involves the law. So this earlier restitution tried to say that in order to actually do justice, the Allies policy would have to take into account the kind of crime that goes after the culture and think of restitution not in property concepts, but as a response to the crime and trying to rehabilitate the group, its culture, and its identity. So that's.
Thank you very much. Thank you very much. I've got a couple of questions, and I want to bring the two of you into conversation. So in order for that to be happening, I'll introduce John Nakuta now, and then ask him for a statement, and then we can go into the conversation. John, welcome again. Yeah, John is a lecturer at the University of Namibia, where he teaches administrative law and human rights law. So he understands himself as a social justice academic. His social legal research interests are in the area of housing, of land justice, access to information, gender justice, indigenous people's rights, and reparation. Recently, he completed a consultancy report, I think, for the Namibian government, with the title Reparatory Justice for Ancestral Land Dispossession in Namibia. Oh yes, they were for the Presidential Commission of Inquiry into the Claims of Ancestral Land Rights and Restitution, which is a very topical, very current and very fundamental debate in Namibia in the political field at the moment. So, John, I'd like to ask you, first of all, or let you shed some light on the restitution debate in Namibia, or even more broadly in Southern Africa. Who's the actors? What's the arguments? What's the objects under discussions, the aims and strategies? What do you as a lawyer see as the appropriate framework or a lacking framework? And also, how does that feel of post-colonial returns? How is that linked to issues of cultural genocide, cultural reconstruction, or even broader issues like the land issue?
Thank you very much, Larissa. And welcome. Thank you very much for the invitation to participate in this very, very important debate. Also, a very welcome to, is it Leora?
Leora.
Laura, okay, thank you very much. It was nice listening to you. I will start by saying that this for me is also a new debate. And I'm participating in this discussion with a view to learn. I'm, as you've, in your introduction, you've mentioned that I'm mainly concerned with other issues. Of course, the issue of reparations and restitution for dispossessed ancestral land, the genocide issue is very currently very topical in Namibia. So I would start by highlighting some of the broader issues relating to restitution in general, and as part of my input, and then that is now in Namibia. And then I would then, in the latter part of my input, then zoom in on the topic of return of artifacts and human remains as it pertains to Namibia. So if you were to allow me, it's like the issue of restitution in Namibia, there are several things that stands out and bedevils the debate. And I use the word bedevils the debate, bedeviling the debate very deliberately, because the issue of restitution in general in Namibia it's a very complex one and a very sensitive one, in fact, a very emotive one. One of the issues that make it so complex is the current legal hurdles that we are experiencing in the area of restitution. That is within the Namibian context. And the legal hurdles, for example, entails that one of the biggest challenges that is currently experienced in the debate of restitution for historical injustices that were perpetrated by the German government is the issue of the then law as it pertains then, intertemporal doctrine of international law. That obviously, as you know, says that at that time when the genocide was committed, there was no such a crime under international law. And for that reason, the German government is invoking that issue as a way to evade what we call here liability. So that is one problem. But on the other hand, even our own laws, and the previous speaker spoke about the individual property or the private property paradigm. And that also is very much at play in the current debate of restituting ancestral land, for example, in Namibia. Because in our constitution, under Article 16, which provides for property rights, it is very much seen as perpetrating or or providing only for private property rights. And as a result, people that are claiming, for example, restitution for their lost ancestral land are facing this legal hurdle in saying that the Constitution does not provide for collective rights, for, in other words, for those that have lost their ancestral land. Article 16 of our Constitution is then seen as a big hurdle for them to access justice in this regard. And another problem that we have seen playing out in our courts, even as late as last year in August, is the very narrow understanding of who can approach a court for justice in Namibia. In Namibia, our rules of locus standi is very much based on the Roman Dutch rules. And that is that those ones that can approach the court, in other words, that are having locus standi, are those ones that are personally, directly affected by and have a substantive interest in the outcome of the matter. And that is a serious legal challenge because 8 people last year from the Haikom community. The Haikom is a sub-tribe of the Bushman people, the San community. And in the mid-50s, the Etosha National Park was forcibly taken from this group. And as part of restitution, the Haikom community wants their land back. And our courts threw the matter out simply on the basis that those that claimed, that instituted the case does not have the necessary locus standi. So that is the legal hurdle that we are having. And then also with regard to the restitution debate, another problem that we are having is this whole conflation, so to speak, of development assistance that Namibia receives from Germany versus compensation. It's conflated because, and it's conflated unnecessarily so, because restitution is a form of reparations. And it's an entitlement under human rights law. Whereas development assistance is not a legal entitlement, but the debate of restitution currently in Namibia is made difficult by the insistence that it should be linked to the level of development aid that that the German government is currently providing to the Namibian government. And one last thing that I think that needs to be mentioned is also currently with regard to the discussion on restitution is, as you've mentioned it, who are the actors involved? And currently, and I want to use your word that you are saying, the current debate or so-called negotiations is very much executive dominated. Yes, there are role players such as communities that are affected, that also sits at the negotiation table, but the process is very much executive dominated, and that is a problem. In fact, last night during our, there's also the impression that the current agenda is being set by the German government. And some of us are questioning, how can the German government, which has been accused of the then German government, that has been accused of these very vile crimes that has been committed, like genocide, how can the perpetrator set the agenda? And so, for example, last night, during the State of the Nation address, the president in passing, for example, mentioned that the compensation that is now being offered by the German government, in his words, is so ridiculous that it's seen as an insult. So these are some of the things that are bedeviling the restitution debate at the moment. My last second part of my input deals with the return of artifacts and human remains as the focus of this discussion. I must admit that currently in Namibia, the debate is really not the general debate for the return of artifacts and human remains are not very much part of the national discourse. And there are several reasons for that. Several reasons for that. One is that because of the museum culture that we are having in Africa, that museums are, in Africa, we've got a different way of preserving our heritage, and not necessarily through museums. So that plays out. So the discussion of the return of artifacts and human, especially artifacts, as I said, is not that uppermost in the national discourse. Also, another reason why it is not so much part of the national discourse is that people don't know what is kept in some of these European museums or some of the museums in North America. So the question is, how can people participate if they, in the first place, doesn't know what is being kept in some of these foreign museums? Another thing, yeah.
I think we need to wrap up a little bit.
Okay.
I think we remain with a couple of minutes only for the session.
Okay, maybe I can stop here, and with the questions I can, so as to allow people to come in, then I can answer some of the things that I did not say.
Yeah. No, but thank you very much, because I think that really places the restitution debate in this broader setting. And what I take from Leora's and your presentation, it's quite interesting, this whole debate on property, that comes up again and again. And I remember that Nikita Devan yesterday in the opening panel, she spoke of the, I quote, capitalist idea of the return to the rightful owner, to the one and only rightful owner. And as fair as that is in those cases where we can return objects, Leora, you have stressed the initial return campaigns were about collectively owned heritage, about Judaica, Jewish ceremonial objects. And that is actually a kind of sort of objects that can really be compared to the objects that we have in German museums, for example, Namibian cultural artifacts, that have a meaning for communities and groups on a collective level. I'd like to ask you about this, because I think we've got 3 minutes left only. I'd like to ask you this question that both of you have touched upon. How can we broaden actually the access to the negotiation and the debate on return, so that we don't have rightful owner individuals, we don't have only states and national representatives, because that's something that we learn from those early waves of Jewish claims, that the coalition or the group of actors that have to join in and negotiate the topic among themselves needs to be a bigger array, a broader spectrum of interest stakeholders, let's say stakeholders.
So thank you, Larissa. I wish we had more time, because each of the legal hurdles that John just mentioned was also a hurdle in the earlier restitution struggle. And there were very interesting responses that not only were articulated, but were in the end accepted by the allies and changed in a radical way the restitution policy that was advanced. But let me stick to your question about restitution to whom. And it's interesting because law in this debate usually is seen as doing justice to a past injustice. But in the early Jewish restitution, law itself seemed to be the hurdle, because the policy was, because after the Holocaust, there was a huge category of heirless property created. And according to the law, this heirless property had to go back to the state of origin. And the Jewish organizations internationally organized to say this would create a huge injustice, because not only some of these states took part in the crime, it is also the Jewish communities were very scarce there, and they have left as refugees elsewhere. So it cannot be that these states or these communities will receive it all. So one of the most innovative turn was to move from the state, or to overcome the demands of the territorial state, to go back to the community. And I just want to say, to quote one paragraph from a letter written by law professor Jerome Michael to General Hildring, the American general, in support of overcoming legalistic restitution to the state and giving it back to the people. And he says something, and he says this way: these objects, which means the books and so forth, must be so disposed, so disposed of that they can be used as the Jews who created them, and the Jews who throughout the centuries lovingly collected and cared for them, intended that they should be used to serve the spiritual and religious needs of European Jews, of the Jewish people as a whole, and of all humankind. End of quote. This is a letter written in June 1946. And it is trying to move us to a community-centered restitution to the Jewish people, which is not an entity in international law at the time. And one final word: it was accepted. These demands overcome the demands of state, but this was created a precedent in which a community was given advantage over a state in order to use and reuse its culture in its reconstruction. So the very act of restitution, the very process of restitution, was seen as a process of doing justice and returning the agency and the voice to the victim group. So I think this really connects to the concerns that John was raising, as now that we are still looking at states as opposed to the tribes or to the communities to whom these properties belonged, were created, and so forth.
Yeah. I'm getting a signal that the next two speakers will join us in a minute. So John, I'd like to, we need to actually postpone your statement, it seems, to the concluding panel, but I'll ask you in the concluding panel, whether you can take lessons, you know, to be learned from this example that Leora has presented to us, and that really seems very, very insightful. And I think we'll go to the last session and then maybe make the connection, what can be learned for the Namibian case.
No problem. We can do that.
Good.
Okay.
So, yes. If nothing is happening, then the floor is back to you. Then okay, here's Alex. Hello. Okay, and Aisha. To welcome Aisha as well. Good. So yes, okay. Sorry for a second of doubt and searching. So welcome, Alex and Aisha, to the second panel, or the second sub-panel, let's say, where we'd like to explore the role of law and ethics still a bit more. I remember that John Nakuta, in another talk, he said, law is a colonial tool. It's been a colonial tool, but how can we nowadays appropriate law also as a tool for decolonization? And I think that's a really interesting question. And law is one thing, and then there's also ethics. So we'll also debate the relationship between the two. I'd like to introduce the two of you. First of all, Ayisha Osori is a lawyer, a writer, and development practitioner with experience in the public and the private sector. She's actually licensed to practice law in Nigeria and in the state of New York. So I think that's really interesting because you sort of straddle different legal systems as well from your background. Ayisha is now the executive director of the Open Society Initiative for West Africa. And that initiative is a grant-making and advocacy organization based in Dakar in Senegal. The institutions or the initiative's mission is to promote and support open societies, inclusive democratic governance based on transparent and accountable institutions, active citizenry, and economic advancement. So welcome, Ayisha. And
thank you.
I'm really glad that we were able to bring together so many different perspectives. And last but not least, let me introduce Alexander Herman. He's the Assistant Director of the Institute of Art and Law, an independent educational organization based in the UK. He's written, taught, and presented on an array of topics in relation to art and cultural property, including on restitution, international conventions, copyright, digitization, museum practice, exports, and art collecting. And his writing has appeared in, for example, the art newspaper, The Globe, Mail, and The Guardian. He's trained both in common law and civil law legal systems and has practiced law in Canada. So welcome, Alexander. I'll turn to Ayisha first of all. I'd like to ask you to share with us, first of all, how the report that has already been mentioned a couple of times since yesterday, how the report by Felwine Sarr and Benedict Savoy and the pertinent debate have been received in Western Africa, and how these debates and discussions are continued locally among cultural workers, scholars, artists. What is it that are you currently witnessing in terms of debates?
Thank you, Larissa, for your kind introduction, and thank you to the participants and everybody else who's listening in. If John, who earlier spoke, says he was here to learn, then I think I would put him at maybe high school level and me at primary school. So I'm the biggest learner here, and will be speaking mostly from a civil society point of view. I studied and practiced law over 20 years ago, so I hardly even consider myself a lawyer anymore. But full disclosure, Felwine Sarr sits on the board of the Open Society Initiative for West Africa, so he's my board chair in effect. And so we work very closely together. So of course, when Larissa asked what has been the impact of the report on West Africa, I would say it's been huge, not just on West Africa, but even within Open Society foundations in general. I'm not sure how many people know, but last year, the Open Society Foundations launched a $15 million 4-year grant to fund the conversation around restitution and the return of African cultural heritage back to the continent. So there's been a lot of interest, I would say, from the artistic communities, from the think tanks, from the intellectuals, the artists, people like Felwine Sarr, the philosophers who understand the importance of having the art returned, that it's a lot more than just restitution and the return of property, but it's almost a return that enables us to have the very difficult conversations that we're trying to have in Africa as a continent right now around our development, our place in the world. So restitution is, as I said, more than just the property. It's symbolic, it's futuristic, it's philosophical, it's emotional, it's cultural, and there's been a lot of interest. I would start with saying that the ECOWAS, the Economic Community of West African States, on the back of the Sarr-Savoy report and all the conversations that generated since it was launched, since first 2017 when Macron made that statement about returning the art and the release of the report, we've seen ECOWAS galvanize. They've recently, at the end of last year, released a plan, what they propose as a plan to aid the return of cultural heritage back to Africa and what they see their role is, and how they will also be mobilizing around this fact. We've seen a lot of interest from the African Union as well, where the African Union has charged the president of Mali, President Ibrahim Keita, to be the champion in terms of returning of, the art ambassador basically for the continent. And he has gone forward to recruit the support of 12 other presidents on the continent to support that drive. And one of the ambitions that they have over the next couple of years, in addition to marking next year, 2021, as the year of African culture on the continent, one of the things they want to do is also to take part in this conversation around the return of cultural heritage to Africa. So right now, the serious conversation is really about, why is this urgent? Why is this important? Why is this a chance? Why is this a great chance for us to change the narratives around our past and how we reimagine our future? How do we engage? I liked what Leora said earlier about restitution and memory. It's about healing. It's about making a connection with the past and then re-socializing what we know about ourselves and these materials, this cultural artifacts, and how that will help us move forward and re-engage not only with ourselves, but also with the rest of the world. I think in the conversation around restitution, many are excited by the fact that with the discussion, there's an opportunity to redesign, so to speak, the relationship between the West and Africa, or Europe and Africa, to reimagine that relationship going forward. There's also, for me, a key element, which again, right now we're talking about Pan-Africanism on the back of the African Continental Free Trade Agreement and what that will mean to the people of Africa. So again, the conversation is all wrapped up in economic, political, social liberation, social development, and reimagining of what we can do. So civil society is very excited, thinking about what their role should be, how to set the agenda. And I think that came up in John's comments earlier, where he talked about the fact that, we don't want Europe, Germany, France to be setting the agenda. We want to be able to set the agenda and push the agenda, whether it's on the technical claims that need to be made, whether it's the intellectual opportunities, the cultural opportunities, the moral and public impact of this type of conversation, and just the advocacy that needs to be done around this topic.
Mm-hmm. Thank you very much. I think it's really so important to hear from those local debates, because also here in Europe, we sometimes tend to center too much on our own concerns, maybe. I'll turn over to Alex before I think I'd like to ask both of you a couple of questions. Alex, you come from law, and you work for that institute that also covers a broad range of difficult sorts of questions and cases. Let me start with a provocative question for you. Do returns need a legal framework like the Washington Declaration? What do you see where's the necessity for legal frameworks, or maybe is there no necessity for it? What is the relationship between legal and ethical frameworks? Where do you see the potential for making things happening after all?
Well, danke, Larissa, and vielen Dank für die Einladung. I thought I'd say a few words in the language of Goethe, because we are at the Goethe-Institut. But unfortunately, the rest of my talk will be in the language of Shakespeare, so you have to live with that. Not only was that a provocative question, but it was a very multifaceted one. So I'll try my best to answer it. I think what I would say about whether law can assist in restitution, we need to look at certain models, pre-existing models. So there are examples where the law can require restitution. And there are examples where the law can prevent or act as a barrier to restitution, a little bit along the lines of what John Nakuta said earlier on the panel. But if we look at examples of where the law requires restitution, where restitution becomes an imperative, one of them I think that's quite useful is the law that exists in the United States for repatriating Native American cultural objects and human remains. So that's the Native American Graves and Protection Repatriation Act, NAGPRA as it's known. Now that's been around in US law for 30 years. And it has resulted in thousands of human remains and cultural objects being repatriated to communities. So it goes back to what Leora was saying as well. The return is to a tribal community as opposed to strictly to individuals, although there are ways of returning to individuals under that law as well. So that's an interesting model of how you can have restitution that is actually guided and required by the law. Now, the flip side to that are situations where the law acts as a barrier to restitution. One classic example, if we're talking about cultural objects, would be in France, where there's a strict rule of inalienability of public collections. So what that means is that if an artifact forms part of a French public collection, whether at a museum, a library, or an archive, it cannot be removed from that collection. That is what inalienability under French law means. So if you wanted to sell it, or destroy it, or exchange it, or give it away, you would be prevented from doing so by law. And that includes restitution. So they've had a big challenge in France in trying to get around that strict legal prohibition on restitution. And what they've tried, I'd say a couple of solutions to that problem. The first is, well, if there's a legal restriction, if you want to return specific items, then you get a new law passed, a law that deals with those specific items, which allows a French museum or a French collection to return specific items. And that's what happened in regards to human remains that were in French collections that had come from the Maori people of New Zealand. When the Te Papa Museum of New Zealand claimed those back, the French museums had to lobby, had to advocate for change in French law in order to allow those specific items, nothing more, to be restituted. So that's one option. The other option is you avoid the ownership question and you focus more on loans, long-term loans. And an example of that working would be the Joseon manuscripts, which were sent back to South Korea. These had been taken by French troops in the 1860s in a punitive expedition, which is what European nations were doing at the same time, it should be said, in Africa. And these were taken from the Korean peninsula and brought to France, and they eventually entered the Bibliothèque Nationale, so the French National Library, and they became part of the French public collections. So when there was talk of restituting these to South Korea in the 1990s, it always came up against a brick wall, which is, well, there's that inalienability of French collections principle. And so what President Nicolas Sarkozy decided, I don't think it was him, let's be honest, it was people working for him, but he would have signed the document, was to send them back on a 5-year loan, but it was a renewable loan, and everybody who was involved in that loan knew that it would just keep getting renewed every 5 years. So what that means is today, those great priceless manuscripts are in South Korea, but legally speaking, they still form part of the French public collections. Okay, so you find a way around the legal restriction. Now that has its problems, and they're understandable ones. For instance, symbolically, it might not look that good if the country of origin has to ask for a loan. They would say, well, this comes from us in the first place. Why should we have to ask for a loan? On the flip side, it can be a benefit because it's a practical necessity. You could say, well, look, where are the manuscripts now? They're in South Korea. South Koreans have access to them. They can be put on display. They can be used for research, etc. So you see that there are challenges. They're more of a symbolic nature, potentially of an identity-based nature. But there are also certain benefits to working around the strict legal prohibitions. Now, a word on ethics. Ethics arise, it seems to me, when you remove law from the space. So we've seen an example, I mentioned the US example where law is requiring restitution, and then we saw the French example where law acts as a barrier to restitution. Well, you might have a situation where law is removed completely from that space. And what does that mean? Well, that means that individual institutions, museums, will have to make decisions for themselves. And when I say museums, I include whether it's the board of directors or trustees, whether it's the city council, whether it's the land or the regional council that's deciding. They have to make these decisions. But you have to fill that space appropriately with an ethical framework. Otherwise, it's absolute discretion. And when it's absolute discretion, you tend to have inconsistent results. And that does not lead to fair and just solutions. So an ethical framework needs to ensure that it has sufficient detail, but not too much detail. And it also needs to have sufficient flexibility, but not too much flexibility. And I'll just briefly say what I mean by those things, and then I'll conclude. If an ethical framework has too much detail, too many requirements, it can act as a frustration for potential claimants or even museums who want to do the right thing. If an ethical framework has too much flexibility, is too open-ended, then it doesn't actually provide any consistency. So you need to have an ethical framework that includes some detail and some flexibility. And what does that mean? That effectively means it provides guidance. So you need a sound ethical framework that provides guidance for decision makers, usually at museums, to provide for restitution when it can be required. So I think that's where I'll end it on ethics, on that ethical space.
Mm-hmm. Thank you very much. I've got a direct follow-up question for you, because you've mentioned those initiatives like ethical guidelines and so on, and we're observing currently that in many European countries, different steps are taken. Germany has released, the German Museums Association has released guidelines for human remains and objects from colonial contexts. The Netherlands, the National Museum of World Cultures has released the process and principles. And then we've got the French report that has not been implemented yet, as far as I know. How do you assess those different approaches taking place and going on in the different European nations in order to address the problem?
Well, I think it actually goes back to what Ayisha was saying about civil society. Ethics, if you think about it, change and they adapt, usually in reflection of societal values and attitudes. So it's not like law, where it can be precise, where it can be predictable. It's something that is going to shift inevitably with time, and it is going to reflect the societal mores of a particular place. So as a result, we'll see a different ethical solution in Germany than we would in the Netherlands, than we would in France. And I think a lot of that relates to the civil society of each country.
What I find interesting that I went to a conference with legal scholars, and one of them gave a paper and said, don't forget that it's not only ethics that constantly change, it's also the law. If we remain insistent, law can be changed as well. So he encouraged us in this debate to think about law as something that can be shaped and molded gradually, and that we shouldn't take it as granted and as static. I think that's a quite interesting encouragement from a legal scholar. And I think this is where the question of civil society comes in again, Ayisha, and I'd pose that question to you. Where do you see the role of civil society in this debate to help shape new ethics, and via new ethics maybe also shape a new legal framework around the problem? And I mean civil society in the affected countries like Western Africa, but then maybe also civil society in the diaspora, and also German civil society as the taxpayers that on whose money German institutions rely.
Okay, thank you for that question, and thank you, Alex, for your comments. It was really very interesting to listen to you. The role of civil society will be different in different contexts based on what the needs are. And in thinking about the role, you could broadly say the civil society who is working on the demand side, which is the demand for return, demand for restitution and reparations, and then the supply side, which is where we would say our partners, for example, each one teach one here in Germany, or the Pitts Museum in Oxford. We're all collaborating with them to start having these conversations about what the guidelines would be. And I think part of what we'll come up with will be a sense of what the legal frameworks will be, or what the ethical frameworks will be. So civil society's role for me would largely be around 4 main areas, which would be the technical aspects of restitution, which would deal on one hand with the laws that need to be changed, the advocacies that need to be changed, the advocacy to focus on those legal changes, including whether the ethical guidelines that need to be produced, not even just on the supply side, which is, I guess, Western Europe, but even within our own countries in West Africa in terms of preparing to receive these things back. Civil society's role will also be there in terms of the technical aspects of demands. My understanding of restitution is, I mean, we're having this conversation sort of in a bubble, but how many African countries have actually made claims, legal claims that are backed by lists and provenance, and have gone through the right channels between the different ministries of culture and ministries of foreign affairs. So civil society will play that role. Civil society will also play a role in terms of the convenings that need to take place. When I talk about civil society, for me, I think about civil society really broadly to include not just those of us who work there daily, but just the public who care, the artists, the think tanks, the academics, the activists, all of those who have an understanding of the importance of the cultural heritage and why it should come back. And I think the final thing I said is advocacy. We see a role for civil society in playing an advocacy role. And when you mention the diaspora, that would be a role for civil society in diaspora to aid or to support or to amplify the voices coming from Africa and West Africa demanding this back. For me right now, even the conversations happening in the US around racism cannot be, and the way that African Americans are treated cannot be divorced from the conversation around colonialism and history and past and knowledge and culture. So they're all intertwined. So for me, I see a very big opportunity for collaboration between civil society in countries in Europe and America to help build and amplify the advocacy that's required to help push, for me, less the legal. I'm not saying that the legal is not important, but I'm hearing Alex say that legal could be an obstacle. So to push the moral and ethical arguments for why it's important for these goods to be returned back to the continent, and what that would mean for the relationship of the countries going forward. I think they would be enriched, we would benefit from more transparency and accountability and more honesty in terms of the relationships between those countries. So that's a bit of what civil society could be doing in this space.
Mm-hmm. Mm-hmm.
Just to go on from that, which I agree with entirely, and to retreat back to what you'd said earlier, Larissa, about somebody telling you that the law can be changed and we can't shy away from that. I really do think that changes in ethics predate changes in law, that it's very difficult to try to force a radical legal shift through the law, because you'll find there's a lot of opposition, and sometimes you haven't tested out some of the ideas in the ethical space. So I do think that a change usually comes, it's a slow change, which can be a bit frustrating, but it comes in the ethical space. And then once the ethics is shifted, then the legal change becomes very easy or not even necessary.
Mm. I think when we look at the German situation, where cultural politics is less centralized than in France, we also see that the institutions that have returned it on the basis that their municipalities and their boards of trustees in those districts and in those cities have agreed to the return. So there is, at least in Germany, it's possible to take a kind of decentral approach to return. And I think that's really important to keep in mind, that a lot can be done, in this way already, without a sort of national legal framework in place. And maybe one has to push these spaces and make steps for more space, to gain more space. There's a question I'm having in mind. When is a claim a claim? I was wondering, when we're talking about this, legal framework is more top-down, and maybe negotiations on a personal, on an institution to institution, curator to curator level descendant to descendant level is maybe a more bottom-up process. You know, when is a claim a claim? Does a claim have to be made through those national bureaucratic structures, or can we take a claim already as a claim when a descendant community or an individual descendant sort of formulates the wish to get access to an object?
Yeah, I think it's, even the term claim can be problematic because it sounds like you're going to court, right? That you bring a legal claim in a sense. But at the same time, you need some level of clarity as to what is being requested. And usually it will depend on the policies, the governance policies of specific institutions. So you might have a policy on repatriation at a particular museum that will say, you know, a dated letter must be sent to the deputy head of collections, and that triggers the process. So that would be considered a claim. If you haven't sent that official letter, then it doesn't fall within the claim rubric, and it's just a casual, informal discussion. Now, that being said, I think a lot of good can come through those discussions before we even get into the claim sphere. Because sometimes you have an understanding or relationship that develops where you find out that the right thing for the object might not be what either of the parties had intended, and they might meet in the middle somewhere. So it is important to talk about discussions as well as formal claims.
I think that's a really important point, that we have to maybe take seriously articulations and articulated wishes at an earlier stage, you know, before they have turned into formal claims, because that's where the conversation and the new ethics of speaking to each other can emerge. And I remember that, I think it was also Nikita Dewan in the opening panel yesterday who said we need actually a new ethics of listening, not only of speaking, not only of giving voice, you know, to actors and to counterparts. We haven't listened, we haven't given voice before, but we must really also change our way of listening and taking what is being said seriously. So I think that's in our debate, that is something that we could maybe look at and intensify. So we'll soon have the other two speakers, Leora and Nakuta, joining us again for a final conclusive discussion. And for the public out there, I'd like to invite you to send questions, because we are getting questions through the chat. And I'd say we've got 20 minutes, and I'd like to suggest we split the session into a first round of responses where you can respond to each other. And then we immediately, after 5 or 10 minutes, go into the questions that have been forwarded to us via the chat, so we can start debating with our audience. But first of all, maybe John, because you were cut short of an answer in our early little sub-panel. How can you relate these experiences of the other panelists to the Namibian situation or to the Southern African debate?
Yes. As I said, I confine myself to the Namibian situation because I'm much more familiar with our own national situation. So I cannot claim to be speaking for the whole of Southern Africa. I want to respond to something that Leora said, and that is rejecting backwards restitution and rather concentrate on a forward-looking approach. This is the same thing that one of the issues that we are facing in Namibia with regard to this. Some people that are not supportive of the whole restitution project. It's like saying, let bygones be bygones and let us look forward and whatever. And some of us are saying it can't be. A gross human rights violation has been committed in the past, and reparation must take place. We can't just go forward with the view, with this notion of let bygones be bygones. So I don't understand what she means with, and maybe if she can elaborate a little bit more on what is meant with rejecting the backward-looking restitution and rather have restitution being seen as something forward. But also there's something very valuable to learn from what she said, and this is with regard to collective restitution. In Namibia, we do have the whole situation, and that affected communities are saying that, as I already mentioned, government is pushing for this notion of national heritage, and some of the communities are saying, but these artifacts were taken from a given person, were taken from a given community, so you can't have that totally disregarded. So it would be quite interesting and very valuable for Namibia to learn from how other countries dealt with the issue of collective restitution. That's what I would contribute for now.
Larissa, can
Yes, of course, directly, you know.
John, for the question, when I said forward-looking restitution, I didn't mean that let bygones be bygones. On the contrary, it is trying to avoid a property framework that looks to previous owners and instead looking at the community and what it needs now in order to be reconstructed. So if the community moves to another place, or if it needs now to build universities instead of old rituals, then this is a forward-looking restitution. Okay. Actually, the Jewish actors were vehemently opposing to what they called a museum approach to restitution, to create a Jewish museum in Europe for dead objects instead of letting these objects become re-socialized with new centers of Jewish life. So this is the forward-looking restitution. But one more point is to connect to what you said before about Germany and Namibia in relation to the avoidance tactic of telling we already paid development aid or assistance, so there is no need for reparation. And actually, in my work on the 1990s restitution debate, a similar argument was proposed by the German government, saying that we will give what we give to you. And there was a big settlement of the lawsuits, but they wanted to frame it as humanitarian gesture. And what I was trying to show is that by going back to the restitution of truth, to going back to the corporations and to their involvement with the crimes of the Third Reich, there was an opposition trying to reconnect, to link the crime to the reparation and avoid this, this is just a gesture of goodwill. So I think, again, with the development aid, there is a need to go back and connect it to the kind of colonial crime. And this is why we need to both look backward in order to understand, to get back the truth, the historical truth that was denied for years, but then to go forward to look at what the community actually needs, or what is the uses that it wants to put its culture for, and not to be stuck with a property ownership framework.
Okay. Thanks for that clarification.
Thank you so much. I think at this point, I'm looking at the chat and I'm seeing a lot of interesting questions coming in already. So do you allow me to take the questions now already and throw them to the panel, and then all of you can answer when you've got an interesting answer. Here's one question to Ayisha and to John. Alexander was talking about permanent loans and circulation, and people like Mbembe endorsed this idea of circulation. What is your stance on this? I think that's an interesting question because loans versus actual returns, I think that's another big debate. So yeah, I'd like to hear your opinion on that.
Ayisha?
Sure, I can go first. Well, I think it's an interesting one, and the practical side of my brain says that it's a good way to overcome the legal obstacles and how long it takes to change laws. Like, for example, I understand that France is set to introduce a new law to allow for restitution sometime. We can expect that sometime before the end of the year. And that was going to be my question actually to Alex, to ask him whether he thought, what did he think about that and how long pretty much could that take? But in the context of the joy and the symbolism of having the saber of El Hajj Tal returned to Senegal at the end of last year, I would say there's a room for loans. I think that it might even help drive the conversation around restitution even further. So while we wait for the laws that are considered to be obstacles to regaining the cultural heritage for Africa, I think loans are a practical way of moving forward and can help deepen the conversation.
I would add to that, provided loans are a temporary, or the circulations or loans is devised as a temporary measure, but it certainly cannot replace restitution in general, because if it were to be a permanent feature, then I personally would be having a problem with it, because these things belong to the people that it was taken to. That cannot be a situation where the original country must now enter into some kind of permanent arrangement to try and get the things back, as opposed to full restitution.
Mm-hmm.
If I may, I agree 100%. So there will be no way that a permanent loan would take the place of returning. But as I said, it would be for me a deepening of the conversation, a helping of both sides to understand what these cultural effects mean to the communities and the people that they've been returned to, and help even drive advocacy. But yes, in no way would that replace the actual restitution or reparation that should be taking place.
A loan, just to add to that, which makes perfect sense, a loan can sometimes be a good vehicle to deepen a relationship. So even though it might not seem as the ideal end point, it can be a stepping stone to something more. So, because when you have a loan, forget the roles of borrower and lender, but you have two parties who have to come together, right? You have to discuss, you have to do reports on the item, you have to check status and things like that. So you're always going to be in a relationship when you're in that loan situation. Now that might not be ideal, but at least it can be a stepping stone to something further before the law can change, because as Ayisha was saying, in France, that can be a long process, and yes, it can be.
I wanted to add something. I'm not sure that thinking about loans as opposed to ownership allows us to really see the more radical potential of restitution as overcoming thinking about property as borders or boundaries of who will get it in the end, as opposed to, for example, the Savoy report looking at relations and relational understandings of property itself, as opposed to object person, to think about the kind of relations. And we have now we have also technology of duplication, of ways to collaborate. Objects add meaning both to the prior owner, but to the new owner. So I think that to keep on looking at the end result as opposed to the relationship that is created through the process, we miss something very important about the potential of restitution. And I don't know where to take it from here. Maybe what Alex was saying, that alone is a relationship. So I would urge to think about it in relational terms, and not just as let's see who is the owner and that's the end of it, because by putting it behind, we don't engage with the other. And I think these objects acquired the meaning, various layers of meaning, and they are important to different communities. So just a thought of how to go about it. And I know that some of the archives, for example, with the Jewish restitution are, you see multiplication in different places, you see ways of collaborating, and we have to take it into account.
Thank you. Thank you for these nuanced answers. Here's another question that goes back to how I introduced the panel. It's about the term community. And I'll pick two questions that I think work nicely together. One is, who's a community and who speaks for whom? I think that's really something that needs to be problematized. And then a couple of questions later, we have this question that is a kind of meta question on the first one. And it goes, don't you think that the debate about community versus national heritage is playing into the hands of museums who argue they cannot return objects when it's not clear who the recipient should be? Or you could also say, when it's not clear who exactly the community is. So how do we deal with these dilemmata?
I just want to say that this objection was raised in the earlier restitution debate that was based on collective restitution, and the Jewish reply to it was very interesting. It was a reply not to go and see the essence, who is the community, but to politically get together and organize various organizations and to create a roof organization for all the Jewish organizations, and to find who is going to represent the culture of restitution. So they organize together in order to not get lost in the debate. And the answer was political and organizational, as opposed to going back to some essence of who is the Jew or where is the community. So and there was a lot of negotiations also with the communities, the remains of the communities in Europe. So I think sometimes organizational or political answer to this kind of question can be a way out of this debate.
I would just like to add that in Namibia, we are actually sitting with that very same problem. That a lot of the returned artifacts from Germany currently there's a lot of politics around it. And one of the problem is that there are so many traditional, of course, given our historical past of divide and rule, where the colonial regimes has set up various traditional authorities, traditional leaders, and whatever. So now the question is, to whom should these returned artifacts be given? It's like in one situation, for example, I'm informed that in one of the communities where the whip and the Bible of one of our former leaders was returned to, it's like there are so many traditional leaders that claim that these returned artifacts must be given to them. So the government is sitting with an issue. So the issue is then, who should then be the recipient of some of these things? So this is really a problem that needs to be addressed. I don't claim to have the answer as to who should be the rightful recipient of this, but it's something definitely that needs to be given serious attention to, especially in our context.
If I may just say a few words on that as well. I mean, I would like to say, I agree that there's no one answer. It would be hard. I like the example that Leora gave, and in my mind, in terms of thinking about political pathway to dealing with this issue of what a community is, the AU, for example, can play that role, and they've started to play that role, or ECOWAS, for example, will play that role. But in terms of speaking of Nigeria, where I'm from, and the Benin bronzes, I think that would be clear that the Benin bronzes would return to Edo State and the people of Benin Kingdom. There would be no confusion. So I think it would also depend on what what the claims are for. In certain cases, it will be clear where they should go and there wouldn't be any ambiguity. There's no sense in my mind that the Nigerian government would think that the Benin bronzes belong to the National Museum as opposed to a museum in Edo State where the Benin Kingdom used to be. But that said, where there's some sense of ambiguity, then the conversation about the political will come back. But I think, again, for me, this is a distraction. Let the cultural heritage come back and we will deal with it. We will re-socialize these aspects. Many of them have lost the meaning that they used to have when they were taken. So we're going to have to interact with them again based on our past and even based on what these objects, for example, have meant in the countries that have held them. So for example, I'd like to think that if Nefertiti ever returned back to Egypt, it wouldn't just be the story of Nefertiti in Egypt, it would also be what it had meant to the people of Berlin in all the years that it's been here. So there's going to be a new way of interacting with these things that will go beyond community. And maybe it speaks to what Leora said earlier about not thinking about it in terms of property and ownership, but thinking about it in terms of the symbolism of relationships and future and imagination and creativity and all those other things that go beyond property.
And actually, there are examples of let's say, differing or overlapping claims being resolved through a consensual process. And I'm thinking in certain settler countries, Canada, New Zealand, Australia, US, there are often overlapping claims from Native American or First Nations or Indigenous Aboriginal communities with regards to human remains or certain cultural objects. And usually the process is that they need to resolve those disagreements before they can receive the material. But in some situations, and they've actually been successful, everybody sits around a table and they talk it through. And sometimes one community will say, well, if this other community looks after it and we have certain access rights, we're satisfied. You know, that's an ideal outcome. But you can actually get a lot done if you base it on relationships, as we've said earlier, and seeking outcomes instead of property ownership and it's mine, not yours.
Yeah. Let me turn to the chat again. Here's an interesting question that links the community question and the property question. And it's a question, maybe it's we can also take it as a comment. It says, if we are to move away from the property perspective of restitution, how could we ensure that the affected communities actually have access, power, ownership of their heritage, as opposed to the state co-opting objects and using them for their own nationalist narratives and agendas? And what I find interesting in that it turns the argument around a little bit. It says property could in the end also be the most radical option, you know, to create a really strong link again between communities. If there is, for example, an individual owner that can claim back that object on the basis of the existing legal framework, then that's very powerful, because I think that's a really final category in the legal framework we have, individual property. Yeah, but there is two more questions that is around something that we haven't discussed yet so much, and that's beyond human remains and artworks, it's archives and the accessibility of archives and the importance of archives, because that is material that provides us with information that can be linked to cultural objects, but that also enables us to create histories, other histories, non-object related histories of the past, of past relationship, violent histories, reconstruct them and discuss them. So I'd like to bring in here the issue of archives and their accessibility. And I think Leora might have a comment on that.
Very briefly, archives and books, as I said, were the center of the first wave. And archives were seen as very important because the Jewish victims understood that part of the archiving that the Germans were doing were in order to get control over their story, their history, and to retell it according to racist categories. So the fight was over creating their own archives and then getting back the archives. So we have to see that the archive is not a neutral thing. It is created for some purpose. And also with colonial archives, we have to not just bring them back, but to rethink the meaning that they are producing and how do we use archives in order to resist or to return the humanity to the people who were denied. Not only they were killed or injured, but their stories were denied to them. So I think it is it's a two-way work with the archives, and how do you get the archive to tell your own story, the relationship between archive and agency, especially to a non-statist group, because archives are usually given to the state. So I think it's crucial to rethink the archive, and there were a lot of answers about to look at archive as resistance to genocide.
Yeah. Yeah. And I think the advantage that we have that in the archival field, there's a lot of experience also with opening up archives, with giving access, with digitization, you know, with taking the information that is embedded in these documents and in these archives and circulating it. And I think that can maybe also be a model for us and for museums. You know, how can archival practice, how can we learn from archival practices of sharing, of giving greater access to cultural heritage and to cultural and historical knowledge, and thereby create post-colonial relationships on a different basis, on an eye level basis.
Can I add something to that?
Yes, please.
I think with regards to digital archives, so the archive, let's say the archives of today from historical episodes, I think a lot of work needs to be done by museums and archives in the West, but the digitization and the making available of this material with communities of origin can be very positive in this debate on restitution. John had mentioned this at the first part of the panel, that in many cases countries of origin don't necessarily know the extent of the material that is kept in European and other Western collections. So how can you expect restitution claims or even discussions if the countries don't know what's actually in those institutions? I think that's changing. I don't think it's fully there yet, but I think it's in the process of changing. And digitization is helping that. But those countries in the West need to invest in provenance research, work like what you're doing, Larissa, in order to uncover more of the truth about these objects. Because I've even heard stories where in a museum, an artifact is miscatalogued by continent. I mean, imagine that, right? So the museums have a long way to go in order to make countries and communities of origin more aware of what's actually in the institutions.
Mm-hmm. Okay. I think that the whole digitization issue is such an important issue because it really, Corona, I think, has really made it aware that had we been at a point where objects databases had already been publicized, you know, put online, had become accessible for research partners in, let's say, African countries and Latin American countries, you know, we would be working in a totally different mode today. And with the travels that we cannot do at the moment, we are realizing that, you know, this huge backlog, the lack of digitization that is now making everything so difficult and even more difficult in the face of the coronavirus and the consequences of it. And I think also digital access, I think, is so crucial when talking about claims. I mean, how would you make claims in the first place if you don't have a clear image and picture of what is there and what you as a descendant maybe of a victim group would like to prioritize of all those objects that exist and that could come back potentially. So I think we've got 3 more minutes left. That means some 30 seconds for everyone for a concluding statement or some final remarks, or just an open question that you want to throw out and to make us and keep us thinking during the rest of the festival. So let me turn to Alex and then go one by one and allow.
Maybe I'll just conclude by taking on what you just said, Larissa. I think that it can be very useful to look at certain models that exist, and sometimes they're legal models. I know most of my presentation was about ethics rather than law, but sometimes legal models are interesting, and I would just draw people's attention to the US law that I mentioned that deals with Native American graves and cultural objects. There's a requirement to inventorize. So museums have a positive obligation to make inventories of collections and then send those to the particular groups. So that's a legal obligation they can't get out of. And I think we could start thinking about those kinds of positive obligations, maybe not necessarily through the law, but through some kind of agreement or consensus to make that material known to communities of origin.
Good. Ayisha, 30 seconds.
Yeah, sure.
In a nutshell.
I just want to say, yeah, my nutshell is, I think this is really timely conversation to be having, not just in the context of Goethe and the Latitude conversations we're having over the next couple of days, but just generally around the world right now as we try to reimagine a better future. I think in addition to everything else that Corona has taught us, Corona has also showed us that there's a lot more that we can do to make our societies more just and more fair. And it's heartening to see that some countries are making the commitments that need to be made. I just want to mention quickly that I heard that Emmanuel Kaserahu, I'm not sure if I'm pronouncing that well, was recently appointed to head the K Branly, and he has a lot of experience in restitution. So seeing that kind of appointment coming from France gives us hope on the continent that France is taking this seriously and countries will follow the lead. And we'll get, the traction that we need to get these things back to Africa where they belong.
Thank you very much. I hand over to Leora for another 30 minutes, 30 seconds.
Since a lot of the discourse is about memory and amnesia, and how we return the memory to Africa and so forth, I think that one important thing to look at is the amnesia or the lack of memory of law itself, of previous struggles and previous achievements, because we keep on thinking that we reinvent the whole thing, while the law has dealt with it, and for very important reasons, it put it aside so that some models that were working in the past are not available for us now because of this legal amnesia. So I think that the comparative work is not just about present contemporary issues, but also about going back to the past and looking at the solutions that were there, because they are very relevant to today's debate.
Thank you so much. And the last 30 seconds go to John.
Yeah, no, thank you very much. I found this debate very, very useful and educative, and Namibia certainly can learn a lot from this. I actually like the idea of the guidelines that has been developed, the idea of guidelines that has been developed in some European countries, and I think Namibia can learn from it, because one of the problems that we are facing is, like I was informed, for example, that human remains has been repatriated 10 years ago. But in the absence of guidelines, government doesn't know how to, it's not clear in terms of how to deal with some of these things. So what I take from this very, very importantly is that the need to develop guidelines that would inform the process, that would be very clear in terms of how the very issue of return of artifacts and even of human remains can be dealt with in a very holistic and detailed manner that is very collaborative and participatory in nature. So that would be my contribution and my take home from this discussion, the importance, in addition to everything else, the importance of the development of guidelines, and we can learn from that. Thank you so much.
Thank you so much to all panelists now. I think we've really pushed the limits in terms of time, but it's been such an interesting debate, and there's still more feedback on the chat. Maybe at 7 o'clock, when Katharina and Peter do a little review of the day, we can take in some of the questions. But for here, thanks so much for this wonderful and nuanced discussion. And I hope we'll all meet again in other spaces during the rest of the festival. Goodbye to the audience as well. Goodbye.
Goodbye.